Lita Filippi.
Thank you, Mr. Speaker. Earlier, we heard from Chairman Craven that this is a strict codification of Roe v. Wade and nothing more. That all it is a strict codification of federal law. And I think the biggest example of how that is simply false is the elimination of the crime of fetal homicide in this proposed bill. There's nothing in Roe v. Wade which protects a third party from prosecution for criminal homicide for an act he does to a mother who does not want to have an abortion. It does not protect someone who has taken away a woman's reproductive choice. And to fix this glaring error in this bill, I move amendment LC 000-518/21.
Lita Filippi moves amendment LC 000-518/21. That is seconded by Representative Newberry, Representative Roberts, Representative Nadone, Representative Chippendale, Representative Price, Representative Quattrochi, Representative Place, Representative McLaughlin, Chairman Corvesi, Representative O'Brien, Representative Ella Wilkinson. Proceed, Lita.
Thank you, Mr. Speaker. On page 3 of the bill, starting at the very bottom, is the statute dealing with the willful killing of unborn quick child. Now, a quick child is defined in there essentially as a viable fetus. The existing statute has been assailed because it has sought to impose criminal liability on doctors as well as pregnant mothers, but critically also on third parties. The constitutional question arises from the criminal liability against pregnant mothers and their doctors. This amendment takes out mothers and doctors and solely focuses the crime of fetal homicide on third parties that cause an abortion without the consent of the mother. I view the intent of the elimination of the quick child statute in full and the desire to not amend it, I view it from that which was testified by the ACLU at the committee hearing when they were questioned about this. They want to eliminate the crime of fetal homicide because they want to deny personhood and legal status to a fetus. There is nothing in Roe v. Wade or any cases which deny legal status to a fetus. Nothing. If we eliminate the quick child statute and someone poisons a mother with the intent of killing the fetus and the fetus dies, the only crime we can go after them for is an assault on the mother. Through the mother. We are no longer having a crime for what that person did to the fetus. I can't understand why we would want that as a society, to deny legal status to a fetus. In fact, Roe v. Wade endorsed the concept of legal status by saying in the third trimester, the state has a compelling interest in the potential life of that fetus. This contradicts Roe v. Wade, what we're doing here, contradicts the principles articulated in Roe v. Wade in the subsequent cases. By way of a review of national law, only 10 states do not have a fetal homicide law. 23 states that do have it apply it throughout pregnancy. We are only one of 8 states where our fetal homicide law applies post-viability. Our fetal homicide law is restrictive. It's only post-viability. You know, Representative McEntee, you said, our body, our choice. This amendment is aimed at punishing someone for homicide, for manslaughter, who takes away your reproductive choice. And that person should go to jail for a very long time for the crime of homicide. Thank you, Mr. Speaker.
Chairman Craven.
Thank you, Mr. Speaker. I rise in opposition to Leader Filippi's amendment. Uniquely, I guess, amongst my fellow colleagues, I spent, I think, the most amount of time of anybody who spent time in the Attorney General's office prior to my coming to this august body, 10 years almost. There are a lot of prosecutorial tools that are available to the prosecutor to handle the fact pattern that not only is spelled out by Lita Filippi's suggested concerns, but it's happened. There are cases where something of this nature that would invoke these concerns have in fact happened. In one instance, 2016, they charged the defendant under this statute. Guess what they did? They pulled it back. Why? It was unconstitutional. Well, then they went on to prosecute under another theory. That other theory led to that person doing the rest of his life in prison. In your scenario, it might be an assault with intent to do bodily harm, an assault with a dangerous weapon. It could be a foot, something that would strike the mother's belly with the intention of the obvious injury that would come from a third trimester abortion, or pregnancy rather, to intentionally cause that to happen. But I'm talking only about my opinion. And interestingly, although I thought about it, I am not the Attorney General. So guess what I did? I thought I'd ask the one we got. Because under our Constitution, there is one and only one person who can charge a felony. The Attorney General himself. So he sent me a letter today. If you don't mind, I'd like to read it. Dear Chairman Craven, got the name right. I write today to address questions raised by the committee regarding House Bill 5125 sub A and its repeal of Rhode Island General Law 1123.5. That's the statute that we're talking about, the so-called quick child statute. I fully support the sub A of 5125, and I assure the committee that this office has the prosecutorial tools it needs to protect the public in the event of its passage. The repeal of the quick child statute will not impede this office's ability to prosecute crimes against a pregnant woman. In fact, based on our review, the Attorney General's office has not charged the defendant under this statute in at least 20 years, and due to significant concerns about its constitutionality, would hesitate to do so in the future. Furthermore, in my judgment, this office has other sufficient prosecutorial tools at its disposal to protect pregnant women. I understand the argument, the legal argument about the issue of creating a legal standing in another context, in another part of the law, so that one who wished to attack the constitutionality of Roe versus Wade or its subsequent statute that we might pass in a bill would want to say, well, let's leave that quick child statute in place because the fetus has a status, or at least the perception of a status under that circumstance. What we do know is we don't need it, according to the Attorney General, for prosecution. I believe that we have, and I take great pride in having voted for and supported Peter Neronha for Attorney General. I think his word and my assessment of what the law is, there is sufficient prosecutorial tools to punish the terrible fact pattern or potential fact pattern that Lita Filippi proposes. As a result, I oppose this amendment. Thank you.
Representative Ucci.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I rise in support of this amendment. There is no reason to remove this statute, to make a strict codification of Roe v. Wade. This is the result of powerful lobbying forces trying to push an agenda. We're taking a tool away from the Attorney General because it may be constitutional or maybe not. Whip Edwards has spent his career taking unconstitutional things out and doing all of these things. Yet we're using this as an opportunity under the guise of needing to codify Roe v. Wade to slide something else out. It's unconscionable that someone would attack a woman if the person's pregnant and not have every tool available to prosecute them. And I'm sure if it were there and the circumstances were correct, it would use them. It's not unconstitutional, so why are we taking it out? Why is this the convenient time to take it out? It has nothing to do with abortion, unless there is an agenda here of reading into it and what may happen. This is a criminal statute. And for those reasons, I say we support this amendment and remove this and fix this. Thank you, Mr. Speaker.
Deputy Speaker Lima. Deputy Speaker Lima. Proceed. I think you're good now. Go ahead.
Thank you, Mr. Speaker, members of the House. This is a very difficult day, and we're making a lot of difficult decisions. And I've been beating my head for the last couple of days because I didn't realize, I was unaware that this bill was coming to the floor. I looked at a lot of different aspects and issues of this bill, and I have resolved them for my comfort on what I feel I need to do. But I'm having a serious problem with this quick child issue, and I'll tell you why. What we're trying to do is balance a woman's right to choose, of which I totally agree with, and the state's interest to regulate that of a potential human being. And I watched part of the debate on the quick child, and I understood when the ACLU was testifying and saying they didn't want it in the bill. And I have a question that I want to ask the sponsor of this, because I know it is constitutional. I've been told over and over again what we're doing here is codifying Roe v. Wade. I'm fine with that. 70% of the people in Rhode Island are fine with codifying Roe v. Wade. But this is going a little bit more, and that can't be denied. This has nothing to do with Roe v. Wade. It's going farther. So that's causing me a big problem. With that, Mr. Speaker, may I ask the sponsor of the amendment a question, please?
He looks like he will yield, so proceed.
Thank you, Lita Filippi, and thank you for bringing this issue up. I did see part of the debate in committee, and I saw you talking to, I believe she was from the ACLU, the attorney.
Yes, Attorney Labinger, I believe.
Okay. So the one thing I wish you had gone further, and did you or did anyone in committee, I don't know this. I'm not a lawyer. I'm asking a question I don't know the answer to.
You're better than most lawyers I know.
Thank you, Lita.
You're welcome.
Did it come up, or was there any objection to moving this quick child law out of the abortion law and putting it in, say, a criminal section of law? Because I'm trying to figure out what is going on here with the issue, and I think knowing that answer would help me.
So the argument that we were having over the constitutionality of the quick child statute solely focused around the inclusion of the pregnant mother and the doctor being included in the statute. What we've done is we, in this amendment on the last page, are taking out the doctor, taking out the pregnant woman, and just having it apply to a third party. The notion of whether it should be in an abortion law, my understanding was that they found it objectionable on principled grounds, but not on constitutional grounds. The constitutional issues are cured by this amendment, and I'll speak more on that when it's my turn to speak, but it being included in a bill dealing with abortion, I felt they felt it was objectionable just on appearance grounds, not constitutional grounds.
So the issue of putting it in another section of law, keeping it still criminal, did not come up? It was just not having it in here, you're saying?
The attorney expressed the opinion that it had, and I believe the quote was, no place in a statute dealing with abortion.
Well, that's my question. Could we put it in another statute?
Of course, we could put this in another statute. I wouldn't object to it. I don't see the problem with it being, I mean, we're dealing with this today. You know, we're dealing with the repeal of the Quick Child Statute today, so I think it needs to be addressed today and not in a subsequent bill that goes through the committee process and could pass or die, but.
Okay, I understand. So because your amendment is taking out the mother and the doctor, you feel it accomplishes the same thing that you wanted to accomplish without having to go through a whole nother bill?
This statute is unassailable from constitutional grounds if we pass this amendment.
Thank you very much.
Representative Chippendale.
Thank you, Speaker. I will stipulate that I am not a woman and I don't understand what a woman goes through when she makes that choice. I will also not speak in absolutes. I won't say every woman, I won't say every man. I will say this. The drumbeat of codifying Roe v. Wade has been at the core of this discussion publicly and, of course, in these halls. And it's been clearly demonstrated that we aren't simply doing that. It's unarguable. It's black and white on the page, not controversial. If at some point in my wife and my pregnancy with one of our children, we were struck in our vehicle by a drunken individual, which resulted in my wife losing one of my children, I wouldn't necessarily be comfortable in one particular Attorney General's opinion about how many tools he has in his toolbox. Because frankly, he could get hit by the beer truck tomorrow and we'd have a new one. So I don't care what the Attorney General thinks. I care what the office thinks and what their record is, because we are replaceable. I would want that individual prosecuted to the fullest extent of the law, up to and including negligent homicide. It would only be right. I don't want to hear legal machinations of enhanced penalties. It's assault with a this, it's no. Those are all assailable at the hand of a good defense attorney. We all speak every year when we pass criminal statutes about how we ought to trust the discretion of the prosecutors. We ought to trust our judges, and I don't disagree with that. And it's not an issue of a lack of trust in the Attorney General's opinion, certainly not. But what it is a strict adherence to what Roe has established, which is what we've been told this is. I could not possibly imagine going through an unexpected loss of a pregnancy at the hands of a third party. And I can only conclude, of course, in the context of the debate today, but also in the context of this debate since 1973, that proponents of abortion are loath to allow a fetus, a baby, to attain status as a person, because personhood makes this a very difficult issue. It's a semantic game, folks, because the right thing to do, the moral thing to do, the human thing to do is put another tool in the toolbox of the prosecutors so that the victims can receive a full dose of justice. Let's not rob the living victims of such a horrendous act, like the young child who suffered and died at the hands of that individual did. let's not make the parent suffer even more. Thank you.
Representative McLaughlin.
Speaker, members of the House, I would just ask that you support this amendment, for the protection of the woman and the infant. And Representative Chippendale brought up a good point, okay? We have a problem defining, okay, that this infant, okay, I'll call him this baby. I had, for the last 3 years, a bill in called the First Heartbeat Bill. But what do I see? I see Roe versus Wade, okay? It's been stuck in committee, Judiciary Committee, for the last 3 years. All it does is define an infant, his first heartbeat, as a human being, all right? I don't see it coming out. All right, but what I do see is codification of Roe versus Wade, and the whole thing is a sham brought on by higher powers. Okay, I'm sick of it.
Representative McCannon.
Thank you, Mr. Speaker. A couple of points. On the criminal side, I obviously can't do any better than Chairman Craven. He's one of a kind. But it appears to me that whatever definition is used for a criminal statute must be consistent with the definition under other law. But I'm rising right now to oppose the amendment and to speak about civil law. And I'm quote a case. It's called Perotti versus Gonickberg. It was a Rhode Island Supreme Court case from 2005, and I was one of the lawyers that argued it. And if you read it, you can find very easily that there's a lot of tools in the civil law. If a pregnant woman is injured in a car accident in this particular case, there's a lot of evidence, there's a lot of tools for compensation. So I don't think this is something that is certainly being ignored by our courts, and I think that we are well covered there.
Representative Marshall.
Thank you, Mr. Speaker. Would the chairman yield?
Absolutely.
Mr. Chairman, as you stated, we have a tremendous amount of respect not only for you, but also our sitting Attorney General. And to follow up on Deputy Speaker Lima's question as well as Representative Chippendale's, the question still remains. Our sitting Attorney General, albeit 4 years or 8 or 1 day or many days, is this just his opinion or is it law?
It is law, and I think that you could probably take a lot of solace in the meaning of the question that you're presenting to me by virtue of the fact that his historical research indicates that it has not been used, despite the fact that this fact pattern that could have resulted in a charge under this particular statute has not been used by the prosecutor's office, the Attorney General's office, in the last 20 plus years.
So would you say, though, hypothetically, because everything is hypothetical here,
Sure.
an Attorney General 8 years from now duly elected to office could potentially have a different opinion than what this current Attorney General has stated?
If you're asking me, I've done my own analysis. I believe that this statute is unconstitutional on its face.
Okay. Thank you, Mr. Speaker. Thank you, Chairman.
Representative Ucci.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I enjoy the debate here, and since we're in for a long night, I will opine. This has not been found unconstitutional. Any Attorney General can charge what they want and how they want. There are certain sets of fact patterns where they charge people to get the most that they can. That's how prosecutors work, and that is their job. We are the lawmakers. I respect the Attorney General. I respected all the other Attorney Generals. Since I've been the representative here, we make the law. We make the law, we change the law, and they enforce the law. That's the way this works. This is a criminal statute under Title 11. We have 47 titles or chapters in our law. This is under 11. The abortion law is under health. It's under Title 23. So we have all these abortion things. We're going to codify Roe v. Wade, and 11 comes in. Why? Well, no one's used it in 20 years. So let's take every law that we haven't used in 20 years, and let's just wipe them all out and start all over again. Something's up. This is no harm, no foul to leave this on the books. It's not unconstitutional. Leader Filippi has done a good job with his amendment to carve out the one piece that may be, but our law has not been found unconstitutional. So I urge you to support this. Thank you.
Deputy Speaker Lima.
Thank you, Mr. Speaker, members of the House. Representative Yuchi took the first words out of my mouth. Even the ACLU attorneys testified this is not unconstitutional. To hear the excuses that we've heard, we haven't used it, we can do it another way, don't worry about it, to me that's ridiculous. We were told the issue here today was to codify Roe v. Wade. That's what we needed to do because President Trump could get the Supreme Court to reverse their decision. What you needed was to codify. Get what you need, not what you want. This section has nothing to do with Roe v. Wade. I sat here and listened. I asked questions. What does this, quick child have to do with Roe v. Wade? Absolutely nothing. It has nothing to do with codifying Roe v. Wade. So what are we doing? We're not codifying it now. Now we're extending it. And isn't that what 70% of the people said do not do? I believe it was 70%. I know 70% said, fine, codify it. The way things are is okay. But then another 70%, and my neighbors said to me, don't go further. We don't want it further. So that's why I'm going to support this amendment. Get what you want, get what you need, not what you want. Don't go further. You don't need this. I ask you to support the amendment. It's a great amendment. Thank you.
Chairman Kovesi.
Thank you, Mr. Speaker. So we've talked the last 20 minutes or more regarding the legalese of whether this is constitutional or not. So let's bring something into real life and think about how you would feel if this was one of yours. The New York Post of Sunday, February 10th, contained an article regarding the stabbing death of 35-year-old Jennifer Irigoyen and her unborn 5-month-old child. Originally, the Queens District Attorney brought felony charges against the alleged assailant for the murder of both Irigoyen and her baby, but then had to withdraw the felony count against the unborn child due to the recent enactment of New York State's unfettered abortion law. By the way, you didn't read this in the Journal. No disrespect to my friends who write for the Journal. But you did not read about this. In fact, I don't think you read about this anywhere in any paper. I buy a lot of papers every day. The impotence on the part of Queens District Attorney Richard Brown to bring true justice to 35-year-old Jennifer Irigoyen and her unborn 5-month-old child in the wake of New York's unfettered abortion law is a tragic, abhorrent, and monstrous example of the real-life consequences and ramifications inherent in the passage of this bill. This is what would be a real, practical, legal effect passage of this law would have on potential Rhode Island murder cases exactly like this one. You're going to hear it again later. It's either potential life or actual life. To think it's anything else but that is to be ignorant of biological fact. It has nothing to do with theology, spirituality, religion. It's either potential life, potential innocent human life, or actual innocent human life. To deny that is to be ignorant of biological fact. And I will leave you, so I urge everyone, if you have an ounce of humanity in you, if you believe in justice, you will support this amendment. And I'll leave it on a less serious note, but still, think about the balance. Think about balance in our laws and balance in nature. So here we are discussing this amendment, tragic consequences of passing this law without this amendment. Yet the Federal Migratory Bird Act, you crush an American Bald Eagle Act, you will go to prison for 5 years. Where's the balance in that? Where is the common sense in that? That we have to argue about whether or not we need this amendment in there. Support this amendment, if for nothing else, your own humanity and sense of justice.
Representative Knight.
Thank you, Mr. Speaker. Ladies and gentlemen, I rise in opposition to the amendment. I believe in justice. I've spent my time in the courtrooms as a prosecutor, although not as long as Representative Craven, but I've had my time there. And so, Rep. Lima and Rep. Marshall, for those who sort of question, like, why would you get rid of this? Why would you take a tool that's in the toolbox and get rid of it? Right? And I understand that argument, I really do. I think the reason why you would with this particular tool is that this tool is kind of like a broken screwdriver. From a prosecutor's perspective, it's not really workable. Because if I'm the prosecutor, and God forbid I get handed a case like this, I look at the first sentence, it says, the willful killing of an unborn quick child and is murder. For the purposes of this section, a quick child is an unborn child whose heart is beating. Now, in the prosecution, guess what I have to prove? Prior to death, the heart was beating. So unless the baby or unless the woman happened to be in a hospital strapped onto a monitor, I'm going to have no evidence on that point. Zero. Not in a car wreck, not in a vicious beating, not in a house, not on the street. Then I have to prove who is experiencing electronically measurable brainwaves. All right. If this happens anywhere where there isn't a device to measure measure brainwaves that is attached to the belly, I can't use the statute. I can't do it. It won't work. Discernibly moving, same thing. Now that you could use testimony for the woman, right? So my point is this. This statute was developed to criminalize abortion and to punish doctors for doing an abortion. By tacking on a section at the end that basically says it shall not apply to any individual physician does not change the fact that it is still a broken tool. If we want to have a bill, a law, that can be used specifically to get out of a situation where a woman is harmed and a developing infant is lost, then let's draft it. Let's put it through committee, let's make sure it works, and let's hand the Attorney General a tool that can really, really work. To add to the collection that Representative Craven already talked about of a felony assault, assault with intent to injure, assault with intent to commit certain specified felonies, assault in a dwelling house, which by the way carries life. This is, you can't dress this up. This is anti-doctor, and we should vote down the amendment. Thank you, Mr. Speaker.
Whip Filippi.
Mr. Speaker, it's Whip Chippendale.
Oh,
No, sorry.
I'm sorry, Lita Filippi. I apologize. You are right. That's last year.
Thank you, Speaker. And I appreciate all the dancing we're doing around the real issue. And the real issue is, can you be charged for homicide with killing a viable fetus? Tools in the toolbox. We all know, Chairman Craven, that there's plenty of charges available for assault on the mother. And I appreciate the Attorney General, he's a great guy, but he skirted the issue too. The question is, should there be a charge for killing a viable fetus? Now, I'm just going to briefly read from a November 18th, 2015 WPRI.com story. Man arrested in connection with the death of a pregnant woman last week in Cranston was arraigned on murder and arson charges Wednesday afternoon. Bourne Smith, 29 of Providence, was ordered held without bail pending a December 1st bail hearing during his arraignment in Kent County District Court. Smith is charged with domestic first-degree arson, domestic first-degree murder, and willful killing of an unborn quick child. That's Cranston, Rhode Island. So yes, this statute has been used, and even if it hadn't been used or hasn't been used, we're fixing it. It's not anti-doctor, we're excluding doctors. There is no more constitutional questions about this. So the colloquy between Representative Marshall and Chairman Craven, it's irrelevant. Most of the arguments we've been having for the past half an hour are irrelevant. The question is not what, the question is why. Why do we want to deny this legal status to viable fetuses? What is the moral reason why? Philosophically, is it because it's not a human until it comes out of the womb? If that's your argument, say it. Don't dance around the issue. Don't claim it's not constitutional. Don't claim there's plenty of tools in the toolbox. Let's deal with the issue. We're a debating society. That's the issue. Why do you feel this way? Why do you feel this way? Thank you.
Representative Quattrochi.
Thank you, Mr. Speaker. I rise in support of this amendment, and would the chairman yield for a question?
The chairman will yield. Proceed.
Thank you. Thank you, Chairman. The members who spoke in favor of this amendment conveyed certain benefits of its passage. Honestly, paying close attention, some of the best I've heard from the other side is that we may be well covered by other laws. And also your own statement that you believe that this is unconstitutional. And also, of course, we're hearing about broken screwdrivers, which, by the way, I'm a mechanic and they make great chisels. But, so my question is, what does it harm to pass this? What is the harm?
You're creating a cause of action under the criminal law, or you're allowing to continue a cause of action under the criminal law that is ineffective in, not useful in charging a defendant or a prospective accused under the fact patterns in their offspring or potential other fact patterns that that Lita Filippi indicated in his hypothetical fact pattern. Why? Well, let me tell you one thing. First of all, there's the practice of what's happened in the past. Lita Filippi has just indicated that in 2016, in Cranston, the Attorney General's office charged this very statute. What happened next? That's the real question. You know what happened? They dismissed it under their prosecutorial authority under Rule 48A of the Rhode Island Rules of Criminal Procedure. Why? Because they feared for its constitutionality and they did not want to proceed, create jeopardy on some of the issues that were associated with that 2016 horrendous charge and therefore lose the opportunity to punish that individual. So they followed other potential charges and were successful. So that's what happened in that case. That's the history of the decision they made. Why would you want to proceed as a prosecutor, and I'll refer to what Representative Knight was talking about, where there are elements under the statute that I have that I can't prove beyond a reasonable doubt. which is, I remember from when they told me in law school, it's you better be darn sure that this happened. You have to be able to prove beyond a reasonable doubt. If you have other tools in the toolbox and you want to nail someone for what they did in such a horrendous crime, you do it the most efficient and the most successful way that you believe as an attorney general or an assistant attorney general. I believe I've answered your question.
Thank you for all of that.
Sure.
And I am way out of my league debating with a lawyer, of course, but so would you actually change your statement of you believe that it's unconstitutional to it's definitely unconstitutional?
I think it's definitely unconstitutional.
You think it's definitely, okay, thank you.
Yep.
Representative Vella Wilkinson.
Thank you, Mr. Speaker. I rise in support of this amendment. Many of you hopefully remember back several months when you were knocking on doors during the campaign season. If your district was anything like mine, very often you would have individuals that would ask you where you stood on the particular issue of being either pro-life or pro-choice. And I could tell you that in the times that I ran for the city council, I had people as far back as 2010 asking me where I was on this issue and what would I do to try to protect our unborn children. Now, one gentleman in particular, the first time I was asked this question, I tried to answer him evasively, to be honest with you, and said to him, this is not an issue that comes before a city council. I don't see why it should make a difference to you when I'm running for your local city council woman. And he said to me, because if I vote for you on the city council, there's a good possibility that you're going to run for higher office. And then I want to make sure that anyone that I elect to be a representative of me is representing my views. And it was at that time that I told him that I was pro-life. Recently, we had a number of Rhode Islanders who submitted stacks of petitions asking us not to support the bill that is in front of us, but instead to support the protections that they wanted for the unborn. And that is the main reason why I am rising in support of my brother, Rep. Filippi's or Lita Filippi's amendment. I've had 3 different groups of petitions that were presented to me in the State House. Last week, I had a petition that had over 7,000 signatures. And I presented it that day to the Judiciary Committee. And then within the last several days, earlier this week, I had 2 other petitions. One that had over 5,000 signatures and another with 2,500 signatures. So despite all of the avalanche of emails that I know that we've all received, whether or not you're in the Judiciary Committee, asking us to vote one way or another, I was able to hand over to leadership in this House a total of over 14,500 signatures from pro-life residents in the state of Rhode Island, asking us to not only look at expanding Roe v. Wade, but to protect the unborn. So please, when you vote on this amendment, remember the people who invited you onto their property. Some of them may have invited you into their houses, looked you in the eye and said, will you protect the preborn? And vote your conscience. Thank you.
Deputy Speaker Lima.
Thank you, Mr. Speaker, members of the House. I'm not an attorney, but I'll tell you, Representative Knight, I'll gladly prosecute that case any day of the week. Because when you're pregnant, the tests that you have to go through, ultrasound, blood tests, urine, glucose tests, genetic testing, how the baby's developing, how the baby's being measured, there is enough evidence there. This is not 1973 when Roe v. Wade passed. The technological changes that we have available to us today tell us a lot about that baby, and there's a lot of things that they can fix. So if you have a woman who's 8 months pregnant and her boyfriend doesn't want to pay for that baby, and he gives her some drug to kill that baby, we should be able to prosecute that person. And how do we prove it? That woman, maybe she was yesterday at the doctor, and he gave her the picture of the ultrasound, and he gave her the tests and the blood levels and all that. And she saw the heart beating. Okay, there's your proof. I'd be comfortable in a court of law with that, prosecuting that case any day of the week. And lastly, I just wanted to say that, you know, the stories I'm hearing on why we can't do this, it's never been used, it's not on the books. This was on the books to punish the doctor, really? What Lita Filippi's doing, he's taking doctor and mother out with the amendment. That's what he's doing. He's making it better. He's leaving it there, but he's making it better. There is no reason not to support this because it has nothing to do with codifying Roe v. Wade. I ask for your support. Thank you.
Representative McLaughlin.
Once again, Mr. Speaker, members of the House, once again, I ask you to support this amendment. If you have an ounce of humanity in you, you'll support this amendment. If you support women's rights, and I'm not going to say a fetus because it's a baby, all right? 10 Commandments says, thou shalt not kill, all right? Thou shalt not kill. All you're doing right now, if a brutal act like this is committed, someone who wants to get rid of a baby, okay, and a woman who suffers the consequences by being kicked in the stomach or poisoned, all you're doing is protecting her. And I'm not an attorney, you know, Attorney Craven, I'm not an attorney, but I'll tell you what, it would be a constitutional challenge if it happened to my wife and my kid. All right, so I ask every one of you to support this. All right, there again, this is a humane thing to do. Whether it gets, struck down or shot down, would be left up to the courts. I'm looking and I'm saying, please vote for this amendment. Thank you.
Representative Price.
Thank you, Speaker. Speaking of that tragedy in New York that happened, I'd call it a tragedy. I guess it was a double homicide. From what I understand, it was very brutal and very intentional. And I certainly was surprised that it was reduced to a single homicide when it was so obvious that it was a double homicide. And I think with modern science and the way they can prove things now through autopsies and stuff, if it's not so obvious with, the way that it was done in New York, that they could prove it beyond a reasonable doubt that the baby was alive at the time. And if we want to codify something else in law, we could leave this amendment like it is, just for the third party, eliminate the doctor and the mother, leave it as it is, and then work on something else so that this is still on the books to use, and then work on something that's even better so that we have something to work with now. So I certainly support this amendment and encourage everybody else to, and thank you very much.
Whip Chippendale.
Thank you, Speaker. I would just like to address, and I don't think I was going to say finally and put it to bed, but I know that won't happen, the prosecutorial toolbox issue, because in the past 9 years, I've learned a great deal about the criminal justice system by serving in this building and serving on the Judiciary Committee, where I learned a tremendous amount about what the prosecutors deal with, what the process is. I've come to know some fine and outstanding prosecutors, defense attorneys, and law enforcement officials. And I don't think a person in this room could possibly make a genuine argument against what I'm going to say. when a person's arrested for a crime, the police and the prosecutors look to stick every single charge they can onto that person. That in and of itself is one of the most valuable tools in their toolbox. And why do they do that? Well, we heard that in 2016, the Cranston assailant was pled down, and it was dropped. Absolutely. That, too, is a prosecutorial tool, which is why we should trust the discretion of our prosecutors. Murder is not equivalent to assault with a dangerous weapon, etc., and all of the mental acrobatics that folks are going through to try to paint it as something other than what it is. We repeatedly in this chamber talk about this very issue and how we need to give prosecutors the tools in order to exercise their discretion. We should not put a prosecutor in a situation where he has to go through all sorts of legal acrobatics to make the most important charge stick. We should allow them to have all the tools we afford them in any other criminal matter, and please make no mistake, this is a criminal matter. I can only, again, conclude that this is a semantic dance, because we can never, and I'm using air quotes on we can never allow a baby to achieve status. Let's reject that. We've come a long way since 1973. Science has taught us a lot. Let's see it for what it is. Thank you.
Representative Walsh.
Thank you, Mr. Speaker and honorable colleagues. I just want to draw your attention to the specific language in this amendment, which is deeply concerning to me at least. Page 1, lines 11 through 15 are the ones that I'm specifically looking at, okay? And it says, the willful killing of an unborn quick child by any injury to the mother of the child, unless it is necessary to preserve the health and life of the mother. Why? If we're talking about, if this is all supposed to be about manslaughter against fetuses, why would there ever be a condition under which it's okay if it's for the life and health of the mother? That seems like a very strange thing to include in here. And just based on that language alone, I would say that we should vote down this amendment, because that really muddies the line between whether we're considering this murder or abortion. Right? So if it's murder, then there are no exceptions for murder. If it's an abortion, then there are exceptions for abortion. And just by the language that you've used in this particular amendment, where it says, unless it is necessary to preserve the health and life of the mother, that shows me in and of itself that this amendment is not doing what it is supposed to be doing. So I will be voting against this amendment, and I urge the rest of you to as well, because if this is about murder, like we're saying it is, right? If this is about fetal personhood and willfully and intentionally killing an unborn child, then why would we have an excuse or an exception for health and life? So that, I think, is very telling as to what this amendment is actually supposed to be doing, and as such, I will be voting against it.
Representative Marshall.
Thank you, Mr. Speaker. I'd like to just refer back to our session in 2018. We continue to talk about toolboxes. We didn't have a broken tool in the toolbox. We had a hole in the toolbox for the defense of the LGBT community. We took a historic step moving forward by removing the gay panic defense law, or defense, in giving that ability for our jurors and juries to take that into consideration. We removed it, and we protected the lives, or hopefully protected the lives, of a community. We removed a working tool of a prosecutionary type legal defense. Even in the midst of our court system saying that it was never used and it would never, ever be used. We took the step forward as a state, historically, to protect the lives of a community. And we passed that law almost unanimously. So I would just urge my colleagues to take that into consideration when we're considering this amendment moving forward. Because we took the right step then, we should take the right step now. Thank you.
Chairman Azenaro.
Thank you, Speaker. I don't normally get up and speak, as everyone knows that, but I can't sit still and listen all night on this debate. We've been debating for about an hour and a half right now. The first thing I want to say is I didn't think there was any need for this legislation at all. Secondly, as Vella Wilkinson said, knocking on doors as you campaigned last year, 2 years ago, I remember being asked, are you pro-life or pro-choice? And I proudly said I'm pro-life. I believe that life begins at conception and ends at natural death. Now, I don't want to tell any woman or man what they can do with their body. It's their body. But now there's another person involved. This person is a baby in the womb. That's another person. I don't say that this is the woman. I say it's another person. All of us here at one time were in our mother's womb. Every one of us. Aren't you all glad that your mother decided to let you live? That's why we're here. Because there was a decision made not to abort us. That's why we're here today. How can we justify anyone killing another person? That's what we're doing. We're justifying the killing of another person. And you can argue it all day in court, because if you have 50 lawyers in the room, you'll get 50 different decisions on a particular thing. But you're actually killing a person. I support the amendment, and I hope everyone else does.
Representative Kislak.
Hi, thank you very much. I rise in opposition to this amendment. We are here today to talk about codifying Roe versus Wade, and this amendment steps in the middle and interferes with our ability to do that as a body. The Attorney General has stated, and we've heard over and over again, that we have plenty of tools already in order to ensure that we can prosecute crimes. We don't need this. It is unconstitutional. We need to remove it. Fetal homicide laws are designed to advance the legal case for fetal personhood rights, and establishing individual fetal rights may lead to restrictions and bans on safe and legal abortion. This is directed at doctors. This is not an amendment that I can support, and I urge us all to vote it down. Thank you.
Chairman Corvesi.
Thank you, Mr. Speaker. Before I begin, let me just say that listening to Sam Azenaro, I had flashbacks of John O. Pastore. That's a good thing, by the way. I'm sitting here next to Representative Kislak, which in and of itself is an interesting situation. And the beginning of Representative Kislak's speech, I agreed with. We're here tonight to discuss the codification of Roe versus Wade. So let's take the issue we're discussing and distill it to its two salient points. This is about the codification of Roe versus Wade, but the amendment has nothing to do with the codification of Roe versus Wade. And quite frankly, anybody in this room, Representative Kislak included, who feels that this amendment is somehow directed towards doctors is disingenuous at best, and I won't say what else at worst. That is disingenuous. This is about the type of assault that happened in New York. This is about protecting a woman and the baby she's carrying. So we have two salient points here. We have codification of Roe versus Wade, and the amendment has nothing to do with watering down that codification, but it has everything to do with an assault on a pregnant woman. Nothing to do with a doctor. There is no reason why that amendment cannot be voted on, and those of you in this room who are hell-bent in preserving Roe versus Wade and to codify it into law, it is not mutually exclusive to vote for this amendment and put it in, because it has nothing to do with watering down Roe versus Wade. It has everything to do with humanity and justice. So, I thank you for listening, and I certainly hope that this amendment passes, because it will not interfere with the codification of Roe versus Wade. It may interfere with other agendas, but it will not interfere with the codification of Roe versus Wade. We're talking about apples and orangutans here. Two completely different species. Thank you.
Lita Filippi.
Thank you, Mr. Speaker. With the exclusion of Representative Kislak, who I think actually touched the issue from the other side, because no one really made the argument that is truly at the heart of this. No one had the guts to say why you're opposed to this. I'm going to make the argument against my amendment that people failed to make tonight. A viable fetus should have no recognition in the law. A viable fetus is nothing until it's born, and it's not entitled to any protection from the state. Thank you.
Representative Carson.
Thank you, Speaker. I just want to say one quick thing. I think my colleagues are correct when they say that this is about Roe v. Wade. I want to make sure that everybody understands that I feel that way. And I think that in my experience as a legislator here, I have found sometimes that when I go to research a law, there's very sloppy parts. They're in the wrong place. The law is written such that items are put in different sections and they don't really belong there. And I think that the real discussion here is that this discussion does not really pertain to Roe v. Wade. We're here today to codify it. I would encourage the defeat of this amendment. I would encourage the supporters of this amendment to put a bill in and look at it as a criminal offense, which is what you're arguing. I'm voting against this amendment.
Representative Phillips.
Thank you, Mr. Speaker. I was not going to get up and speak on this amendment, even though I have my own personal opinions on it. But there's some points that were brought out that I need to clarify with my colleagues here. First of all, there is never enough tools in the toolbox to prosecute murder. We have this, we have that, we have the next thing. But there is never enough to prosecute murder. And with all my colleagues who are lawyers in the room, and there are a few of you, how many times have you thrown out certain charges if the defendant would plead guilty to lesser charges? Well, if you throw this out, you're throwing another tool that you have to prosecute the person who viciously attacked a female with an unborn child. That's point number one. There was another rep that had made a comment about this has nothing to do with women's health and that. It has everything to do with women's health. If somebody commits a crime against that woman and the unborn child, that woman is going to be traumatized. Why would you not want to commit the person or held the person accountable that committed the traumatization of that woman? So I'm urging everyone to support this amendment to get these people that want to do vicious acts against women and unborn children to be held accountable for their actions. Thank you, Mr. Speaker.
Chairman Jakad.
Thank you, Mr. Speaker. Let me just say that, like Representative Lima, I feel I pretty much know where I'm going with this piece of legislation. But one thing I have been uncomfortable with is striking so many sections of existing law in this. And the reason is because we're here today because many of you, the people here, feel that the Supreme Court could overturn Roe versus Wade. That's the whole reason we're arguing this now. And I think there's, I don't know if I'm right or not, but maybe that cuts both ways. Maybe this statute that we have on the books regarding the death of a quick child is unconstitutional, but the same token, maybe it could be constitutional someday if the Supreme Court were to rule that such a statute is constitutional. So we're here because we want to add something to our law because we think that the Supreme Court may make it unconstitutional, but so by the same argument, maybe we should just leave the statutes that we have on the books. It's not like we can just come back and quickly revisit it if the Supreme Court does take action, because this is a once-in-a-generation debate, and it's not going to just come back to the floor really quickly. So for those reasons, I'm hesitant and concerned about taking existing statutes off the books. Thank you.
Representative McCannon.
Thank you, Mr. Speaker. I'll be brief. This clearly is related to Roe v. Wade. I would be happy to co-sponsor another version of this that goes through the 7D process and goes through the committee hearing process and defines the child in a way that, the fetus in a way that is appropriate under existing law. But I think that this amendment as it stands now, it needs to be defeated so that we can get to the core matter, which is to conform our state law with existing law that's been in existence for 40 years and decided by the United States Constitution.
Representative Ella Wilkinson.
Thank you, Mr. Speaker. Once again, I stand in support of the amendment, and I would, with due respect to my colleagues, I would like to bring their attention to the original bill and look at line 11, sub 2, which says, interfere with an individual person's decision to continue that individual's pregnancy after fetal viability. So clearly, the amendment does have a place within this particular bill, because if it wasn't for the interference of a third party, the woman's choice would have been to keep the pregnancy through full gestation and deliver a fully born baby. And I am also in support of this amendment because of the number of women, bless you, because of the number of women, pregnant women, who suffer domestic violence at the hands of a brute who decides that he's going to end the pregnancy when he determines to do so. So once again, I ask you all to vote in favor of this amendment. Thank you.
Representative Roberts.
Thank you. I rise in support of this amendment because I'm having some difficulty understanding why people wouldn't want to vote for this, especially since there's so many who claim to be the voice of women. What is this? This is a bill that helps to protect the woman, not just her child, but if she loses her child, what kind of psychological effect would that have? What if that were your sister? Wouldn't you want to protect that woman's right? We need to vote yes on this amendment for that reason. Otherwise, when we say that, we're pro-choice, is choice just a buzzword for abortion, or does it truly mean for the woman who also chooses life? I urge you to vote in favor of this. Thank you.
Representative Place.
Thank you, Mr. Speaker. I rise in support of this amendment simply for the fact that I do believe it actually, for the first time, we're hearing something that does actually apply to Roe v. Wade. Because in Roe v. Wade, it says the state has a legitimate interest in the protection of the potential life. And I believe this amendment does that. And anybody who votes against this amendment is moving to go beyond Roe v. Wade and denying the potential life that the Supreme Court acknowledged in the unborn fetus. Thank you, Mr. Speaker.
Representative Blazewski.
Thank you, Mr. Speaker, members of the House. I rise in opposition to this amendment. This amendment is all about Roe versus Wade. Representative Maura Walsh hit the nail on the head. Let's look at the statute. Let's look at the amendment. Line 14 and 15. Those words, health and life, that is an attempt to fix this statute to conform with Roe. They failed because it's supposed to read health or life, but they're trying to fix this statute to conform with Roe. Why? Why? I'll tell you why. This is the litigation strategy. The goal is to have this pass and have it be in direct conflict with Section 1 and go to court. That's the plan. If you support Section 1, you cannot support this amendment. I urge its defeat. Thank you, Mr. Speaker.
There are no... Whip Filippi.
Thank you, Speaker. The intent is to bring the statute in court.
Lita Filippi. I'm sorry, Lita.
Thank you, Speaker. I appreciate that, Deputy Whip Blazewski, because the purpose is to bring this in conformance with Roe v. Wade, and that's why the statute's drafted like it is. We do not want to have any conflict with Roe v. Wade, and we were careful about the way we drafted this, so I appreciate you agreeing that this does not conflict with Roe v. Wade. Thank you very much.
There are no other lights. Clerk, unlock the machine. All in favor of the amendment, please vote green. Those opposed, red. Has every representative in their seat voted? Clerk, lock the machine. 32 in favor, 39 opposed. The amendment fails.